number 120, Mestecky versus the City of New York. Counsel?
May it please the court, my name is Christopher Mestecky, Garcio and Garcio. For the petitioner appellant, I respectfully request 2 minutes of rebuttal.
Yes, sir, of course.
Thank you. It is an honor to be arguing a due process case in front of this court involving the property that's owned by my father, who immigrated to this country from a place where notice and an opportunity to be heard were not fundamental aspects of their court system.
Mr. Mestecky, the statute, this you would agree is a case of statutory interpretation, correct?
I do, Judge.
So the statute says that the notices of violation have to be served as directed by Article 3 of CPLR, except that in cases involving notice of violations that are issued by the Buildings Department, there are different rules. How is that not plain on its face?
Yes, Judge. It's actually the starting proposition is that all notice of violation must be served in accordance with Article 3 of the CPLR, and then accept that. And this enumerated exception is a method of substitute service. And the plain language of the statute incorporates a preliminary requirement that there must be an attempt at personal service upon the respondent before you utilize that method of substitute service. And I believe that reading and that interpretation, as was held in Horizon by the Second Department, is wholly consistent with the plain language of the statute and also the legislative history of the statute.
Counselor, the statute refers to a reasonable attempt. Is that language anywhere in CPLR Article 3, a reasonable attempt?
That language is not specifically found in the statute of Article 3.
The reason
However,
I ask that question is because then it seems to me that the reference in subdivision B here to CPLR Article 3 is not to a reasonable attempt as provided in Article 3 of the CPLR, but rather to the persons who are provided for in Article 3 of the CPLR. Why isn't that the most plain interpretation of that language?
I agree with that interpretation. However, the persons that are referenced in Article 3 and the requirements are those individuals. So in order to serve process personally on an individual under Article 3, and in this case it would be CPLR 308, the methods are enumerated. There has to be a personal attempt at service, actually hand-delivering that document to the individual. You could deliver to suitable agent
But
discretion.
what I'm suggesting, I don't know if you understood my question, that it doesn't refer to what the attempt must consist of. It refers to the person that the attempt must be made, so that it's not dictating how.
I believe it does, because the plain language says, as provided for in Article 3 of the CPLR and Article 3 of the BCL.
Well, I think that's the point that's being made. It's whether or not as provided for is referring to the person as opposed to the methodology, because otherwise what's the point of this alternative way of service that's provided in this statute, not in Article 3?
So the purpose of the statute is clearly to make it less onerous than the requirements of service under the CPLR. But less onerous doesn't mean not onerous. And I think that's a distinction that needs to be made.
And isn't attempt pretty clear that you're talking about one, not several?
I respectfully disagree with that interpretation, because the plain language says a reasonable attempt. The term reasonable is there to justify a due diligence standard. Had legislature wanted it to say a single attempt, that language clearly could be there. It could have said a single attempt or a attempt.
Well, it's
but there is
modifying
a
attempt.
requirement.
It's still explaining by how one measures the attempt. It's not suggesting that it's reasonable only because you do it several times.
I agree with that. I think it doesn't necessarily have to be multiple attempts, but the attempt has to be reasonable, and that means that a determination that one attempt is always enough cannot be what the meaning of the statute is.
What good here would a second visit have done?
In this case, if the attempt were reasonable, and I believe there's a whole host of cases that discuss the reasonableness of the attempt, there would be evidence in the record as to the specific attempts to find out where the petitioner appellant resided. Clearly, the tenant knows where he resides. We never had an opportunity at the hearing to address that reasonableness because there was a denial of that request to have the hearing officer appear. However, any case where there's a dispute as to the service, you would have the individual come in and you would examine that issue as to the reasonableness of the attempt. With these notices of violation, on its face, the affidavits of service merely provide knocked on the door, posted. That cannot be what the legislature intended. And I think going back to some of the questions with regard to the understanding the plain language of the statute, you do have to look at the legislative history. And the legislative history, Governor Carey's memorandum filed with the bill dated in July of 1979, specifically addresses this issue. And it provides for this alternative method of service, and the quote, and it's at record 322, is that it's contemplated in quote, in instances where attempts to personally deliver the notice have been unsuccessful.
It seems that you're relying on a conflict between the departments, between the first and the second, and specifically the second department case, First Horizon, I think it's Home Loan Program. I don't remember the rest of the title. And the RPAPL, Section 735, in an analogy to that argument. Do you want to outline those for us?
Sure. The argument in that case was that the RPL had the same term reasonable. It used the term reasonable diligence. And First Horizon...
I thought it was application.
Reasonable application. You're correct, Judge. And in that case, the court reviewed that matter and said that term reasonableness imports the due diligence requirements. If the court just wanted it to be going to the site and posting, if the legislator wanted that, that could have happened. But the reasonableness and the case law with regard to reasonable and what a reasonable application would be, First Horizon said that that terminology is similar, it's akin, and that requires a fact-specific analysis as to what happened on each case for the service. And that is also a significant issue in this case, in that the record is wholly devoid of those issues because...
What effect do you think the nature of the mailings has on your notice argument? The nature of the mass mailings, does it have any effect on it?
I think it goes to the same argument, which is the actual inspector has to not just explain the reasonableness of the attempt that he made, but also the reasonableness of what mailings that were made. And without that witness, clearly the affidavit of service was put into evidence. There's no evidence at the hearing as to the mailings and what happened with regard to those mailings.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, Max McCann, counsel for respondents. The legislature amended the charter specifically to move away from the very service regime that Mestecky is asking this court to impose. And it did so for good reason. And that's because requiring inspectors to serve notices of premises-related violations the same way you would serve a summons and complaint in order to initiate a civil lawsuit doesn't work. The problems with that system are well documented in the record.
So many of these properties are not owner-occupied, but is there a system by which the owners can register or somehow make their actual residence known?
Absolutely, Your Honor, and it's quite easy to do so.
Okay.
The owner of a premises can register with the Department of Finance to receive tax bills at a certain location, their home address, their office address. They can register with HPD, as in fact they should, and they can also register with the issuing agency.
And are those addresses, are they necessarily in New York State or New York City, or could they be anywhere?
They could be anywhere, Your Honor, and that underscores the ease with which Owners of premises can receive notice
Counsel,
under
you
this
say the
scheme.
owner can register? Are they required to register?
I believe under the multiple dwelling law, the owners, depending on the type of property, are required to register with HPD. And if they do so, if they take that one small step, they're going to receive notice, just as Mr. Mestecky did in this case, in 5 out of the 9 challenged
Well,
violations.
They pay taxes, right?
That's correct.
So where do they register the address to where their tax bill is sent?
For 5 of the 9 violations, the tax bill was registered to Mr. Mestecky's home address. And so once he took that small step of registering with the Department of Finance, every subsequent violation that was issued to him from that point was issued to both addresses, the premises and the Bayside address that he listed with the Department
Can
of
I
Finance.
ask you about the proof of mailing? So were the affidavits of mailing attached as exhibits to the answer, or were they presented at any of the hearings?
The affidavits of service were attached to the answer only to explain the things that the hearing officer took official notice of. The rules are quite broad for the ALJs in these types of hearings to take official notice
Oh,
of.
but did the ALJs base it on the affidavits of mailing, or did they base it on this SVBI screen?
That's right. The ALJs would have based it on the SVB1 screening.
That's what I want to, oh, SVB1, okay. Let me just ask you about that. As I understand it, and correct me if I'm wrong, that indicates that the letters were prepared to be sent to this contractor who actually does the serving. It's not proof that they were actually sent or even printed, and certainly not that they were actually mailed.
Respectfully, it is, Your Honor. The Environmental Control Board has a contract with an outside vendor who batch prints all of the notices of violations and decisions that are entered on that SVB1 screen on a daily basis. So it's,
So without something from the vendor, does that screen tell you anything more than that ECB put it on the screen for the vendor to then do what the vendor is supposed to do?
that's exactly what it says, and based on the reliability of the vendor, the ALJs know that if it's in that SVB1 screen, the mailing went out.
Oh, so you're just basing it on the general reliability of the vendor and assuming that it's always done properly?
Well, from the experience of the ALJs, yes, Your Honor, that's a safe assumption, which is confirmed by the affidavits of mailing that are included in the record that we did attach to the answer in order to explain the things that the ALJs are taking official notice of.
But isn't his argument that they were actually mailed just to the wrong address and that wasn't good enough?
Respectfully, no, Your Honor.
Okay.
Mestecky argues that 4 of the 9 violations were only sent to the location of the premises, but it's undisputed that he had not registered another address.
No, I understand that, but that's what I'm saying. Clarify for me, is he contesting that they were actually mailed to the premises as opposed to his other address?
Right, I think Mr. Mestecky is only claiming that he didn't receive them, and
As
of course...
opposed to that you actually mailed them?
Right, and of course, service is effective at the time of mailing, not at the time of receipt. Right. So the legislature considered competing interests here, and it crafted a service regime that balances those interests, and it allows inspectors to make a single reasonable attempt at personal service at the premises before affixing the notice to the premises and mailing the notice to the premises and other addresses that the owner may have on file with the agencies. Mr. Mestecky is asking this court to overturn the legislative prerogative and to undo that solution that the legislature came up with to solve this well-documented problem. Unless there are any other questions, this
Thank
court
you,
should affirm.
counsel.
Thank you.
Mr. Mestecky?
Just with regard to some of the arguments that counsel made, I think a good point that was raised here is that the majority of these items that are contained in this record were never submitted at the hearing below. And 72A Realty Associations versus ECB makes clear that in an Article 78, the court can only consider those documents and evidence that were submitted.
But part of your argument is that they actually mailed it only to the premises, once, right? So you're not disputing the mailing once to the premises for several of these violations,
We are
correct?
disputing the mailing to where the petitioner appellant resides, the Bayside address for all of them. He never received those documents.
Yes, but I thought your argument was that for several of these mailings, his position, excuse me, client's position is that they were mailed to the premises on one occasion, and that's where they've failed to comply.
Yes,
So you're conceding the mailing, you just say the mailing's not good enough.
We're saying the mailing doesn't satisfy the city charter because the city charter requires the mailings to go to multiple locations, not just the premises of the location. With regard to counsel's argument that there was some kind of failure on my client's part to register this property, the only evidence in the record is a tax bill that was submitted by my client a few months after the service, which indicates the address was changed. This issue was never raised at the hearing, and therefore there's no evidence in the record as to whether he failed to change addresses or not. But I think a significant issue is that the mailing requirements also require the ECB to review the files that they have in their own office. And it's our position, and it's our position at the hearing, that the ECB, because of prior violations on this property, knew that he resided at the Bayside address. And had they looked in their own files, they would have mailed all these violations to the...
Well,
to
how
the
many got
property.
sent to the Bayside address?
0. It is our position that 0 of them were received at the Bayside address. And just one final point that I think is important to note is that the transcript of the second hearing has never been produced in the record of this matter, and those involved the October and December NOVs. There's a requirement for the appeals board to review the transcript and the record, and that's gone. It's never been presented. Just for that basis alone, those NOVs should be dismissed.
Thank you, sir.
Thank you.